Hi everyone, Dave Sugden of Evidence at Trial. So, will Donald Trump be on the ballot in November 2024? The Colorado Supreme Court says no, Michigan Supreme Court says yes, and most recently Maine's Secretary of State says no. So, what is going on? By taking a look at the Colorado Supreme Court ruling, we can get a pretty clear picture of the rationale behind keeping Donald Trump off the ballot and why that rationale is pretty stunning. So, let's get into it. The ruling by the Colorado Supreme Court is that former President Donald Trump cannot appear on the Colorado Republican presidential primary ballot because, under Section 3 of the 14th Amendment, he is disqualified from holding the office of president. The 14th Amendment was passed by Congress in 1866 after the conclusion of the Civil War. The concern was about what should be done with folks who held positions of political power before the war, fought for the Confederacy, and then wanted to return to their positions of public service. Section 3 of the 14th Amendment says basically, no, you can't do that. Specifically, it provides that no person shall be a senator or representative in Congress or elector of president and vice president or hold any office, civil or military, under the United States who, having previously taken an oath to support the Constitution, engaged in insurrection or rebellion against the United States. Over the next 150 years, a few things happened. Colorado, for example, became a state, and it, like all states, passed a number of laws that govern elections. For example, in Colorado, if any of us wanted to run for president, we would have to fill out a form. It's literally a check-the-box form where we would have to attest that we meet the qualifications set forth in Article 2 of the U.S. Constitution, namely that we're at least 35 years old, that we've been a resident in the U.S. for at least 14 years, and that we're natural-born citizens. At the end of the form, we would also have to attest that we solemnly affirm that we meet all the qualifications for the office prescribed by law. Now, suppose we fill out this form, but we don't meet the necessary qualifications to run for president. Colorado's election code provides for challenges to the listing of any candidate on the presidential primary ballot. And the timeline to decide these challenges is really fast. For starters, the challenge must be brought no later than 5 days after the filing deadline for the candidates. The district court then must, 1, hold a hearing within 5 days to assess the validity of all alleged improprieties, and 2, within 48 hours after the hearing, issue its findings of fact and conclusions of law. And this all generally makes sense. If a 30-year-old or a 36-year-old fill out this form and a challenge was brought alleging that he or she failed to meet the age requirements, it probably would not require much to assess the validity of this person's candidacy. So a hearing and a ruling within a week is not too heavy of a lift. In this case, however, the petitioners were not challenging any of the boxes on the form, but instead were arguing that Donald Trump failed to meet all qualifications to run for president because he engaged in insurrection on January 6, 2021. Citing Section 3 of the 14th Amendment, the argument goes, Donald Trump is thus not qualified and his name should not be on the ballot. Beyond the obvious difficulty of deciding this type of challenge within a week, one of the issues for the trial court was that the 14th Amendment does not explain how a court is supposed to decide whether someone has engaged in insurrection. For example, does it require a jury trial or is a bench trial sufficient? It says nothing about burdens of proof or standards of review, nor does it say anything about what discovery or evidentiary rules should be followed, let alone whether civil or criminal proceedings are contemplated. Now, to be sure, former President Trump has not been convicted of insurrection, nor has he been charged with it. He's been charged with conspiracy, but let's suppose he was. There is a federal statute, 18 U.S.C. Section 2383, that criminalizes insurrection and requires that anyone convicted of it be fined or imprisoned and be disqualified from holding office. And if Donald Trump was charged with violating Section 2383, the former president would be afforded all of the constitutional rights that are afforded to all defendants in a criminal case, namely due process. There would be no expectation that such a charge could go to trial and be resolved within a week of his indictment. Now, let's also suppose that Donald Trump was convicted of Section 2383 and then tried to run for president. The petitioners in such a case would argue that the former president is not qualified to run because he was convicted of insurrection. And adjudicating whether or not Donald Trump had been convicted of insurrection would be a fairly easy determination. But the petitioners' claim in this case is different. Because they can't argue that the former president was convicted of insurrection, they instead argue that he's not qualified because of alleged insurrection. And because the district court has 5 days to assess the validity of all alleged improprieties, the district court was thus charged to, within 5 days, decide this paramount issue. The court would also need to decide a number of legal questions, such as the meaning of the term insurrection, the meaning of the phrase engaged in, and the court would need to determine whether any of this even applies to the office of the president. Well, 5 days was obviously impossible, so the district court basically took a Goldilocks approach, wherein it did not go as fast as the election code required, but according to the Colorado Supreme Court, the speed was just right. But was it? There was no jury. The trial began on October 30th and ended on November 3rd, with each side having just 18 hours to present its case. The court then issued its final order on November 15th, which was 1, 2 weeks after the hearing concluded, and 2, 72 days after the petitioners filed their challenge. If this seems weird, the Colorado Supreme Court said it shouldn't because Denver courts know what they are doing. The court explained that although Colorado's expedited statutory procedure for litigating election disputes may be unfamiliar nationally, our courts, particularly the Denver District Court, are accustomed to this election-type litigation. Fair enough. And a fast-track case to determine a prospective candidate's age or birthplace can probably be resolved in that statutory time period. But when the issue is essentially determining a defendant's criminal culpability that will result in his or her name being left off the ballot, it seems a little swift. And while the court held that the district court substantially complied with the 5-day rule by getting a hearing and ruling done in 72 days, that's still lightning speed for any other type of litigation. And this fast-track case raises some basic questions of fairness. For example, the case involved several expert witnesses testifying at trial, and yet the court did not allow any of the experts to be deposed beforehand. As for discovery or exchange of documents before trial, how are the parties to know whether they are even close to being prepared for trial? One of the justices in dissent wrote that, "I have been involved in the justice system for 33 years now, and what took place doesn't resemble anything I've seen in a courtroom." And he's right. We'll often hear that justice delayed is justice denied because the time to get to trial takes too long. But when a butterfly has a longer lifespan than a case at the trial court level, it's hard to argue with a straight face that the parties were afforded adequate due process. It will be interesting to see what happens when this case gets to the U.S. Supreme Court. In our next video, we're going to look at the evidence the district court considered during the trial. Specifically, we're going to look at the admissibility of the factual findings that were made in the January 6th congressional report. Folks, I hope this was helpful. If it was, like, subscribe, hit the notification button. If you want a topic covered, leave a comment. If you want to do a deep dive on these evidentiary issues and how they apply at trial, check out our online course page at evidenceattrial.com. Thanks for watching.